Well, thank you for the nice introduction. And today we're going to be talking about a lot of topics: asset protection, estate planning, corporations, limited liability companies, offshore structures. But I want to start today with a very basic of entities for estate planning. And the most basic of entity is a living trust. So let me talk a little bit about living trusts and how they operate. Now, when you hold your assets and you hold title to assets, usually hold them in your own name, a personal name, or perhaps husband and wife. You can have joint tenancy, you can have tenants in common. In other states, they have tenants by the entirety. Those are or community property. Those are the normal methods of holding title. Here in California, we have community property. Other states, they have other types of methods of holding title. But the problem that you run into when you hold title to property in your own name is if you die, what will happen to that estate? That property is going to have to go into what's called probate, and that's a court proceeding. When you go to court, you can imagine what type of consequences there are. You're going to have to go before the judge, you're going to have hearings, you're going to have people challenging the probate, you're going to have expensive fees, attorneys are expensive, everything gets expensive and time-consuming, and a lot of paperwork involved, because really when you look at it historically, if a person doesn't even have a will, they don't have a trust, what happens to their estate when they die? It has to be, by law, everything has to be analyzed. You have to have debts paid, you have to have marshaling of assets. You really need a method of organizing the liquidation of assets upon people's death. So having no planning at all, you're looking at probate. If you have a will, that will is going to have to be analyzed for validity. It's going to have to go through probate. And the probate fees are substantial. You're dealing with percentages of asset value, so your probate fees could be in the thousands, tens of thousands. And time consumed, 6 months, a year and a half is not unusual. There are estates that have been going on for years that they're still litigating. So let's talk about a better planning method. That is a living trust. So what that is an all-encompassing entity to hold your assets. So you take your house, your car, your bank accounts, your proceeds of life insurance, your retirement proceeds of retirement plans, all your assets more or less can go into the living trust. So once it's in that trust, what happens is during your lifetime you have complete control of that asset. Husband and wife or just the sole person can control that. You have signature authority. You're the sole trustee of that living trust. But what happens upon death is the successor trustee steps into your shoes. They step in right away into that position of authority over the asset. So here you have a situation where upon your death, it doesn't have to go through probate, it doesn't have to go through a litigation process, it doesn't have to go to court, but your successor trustee takes immediate control of that asset. Well, what happens to that asset once they take control of it? Well, now they follow the trust agreement. So in that trust agreement, you designate beneficiaries. You can designate your children, you can designate charities, you can designate whoever you want. You can set up trusts, continuous for other people. Educational programs can be set up. You can do tiered distributions over time. For example, perhaps now if you have young children, you don't really know their personalities yet. You don't know what they're going to be like at age 18. Without a will or without a trust, children at age 18 get the entire distribution. And with life insurance, everything, the proceeds could be substantial. You could be dealing with $500,000, $1 million, $1.5 million. And you don't know what 18-year-olds will do when they get that kind of wealth. You know, maybe a sports car, maybe, spend it all within a week or two. That's the consequence. So instead, what we do is we give the trustee the authority to designate that beneficiary's assets, perhaps just income from that asset, up to a certain age, maybe from 18 to age 21 or age 25 when they finish college, for example. That would be a good designated portion of the estate to go to. And different children reach different ages at different times. So you have perhaps one child becomes 18 and goes to college. The other one might want to do further education. Let's give the trustee some authority. Perhaps they can designate that this payment gets made for the purposes of education or maybe health care, or perhaps just maintaining their lifestyle upon your death if you have young children. So then at a certain age, we can take part of the main estate and give it to him. So we think at age 25, that would be good. Maybe we give him 1/3, say $500,000. At age 30, 1/3 again, $500,000. At age 35, $500,000. By that time, we figure the children are old enough, or perhaps they have children now, they're more responsible. And by breaking it up that way, also we don't have to worry about the beneficiaries getting involved in lawsuits or marriages and divorces and all the things that families tend to go through these days. So through that living trust now, we've been able to, upon death, get the asset, the control of the asset to a successor trustee. And not just one trustee perhaps, but maybe co-trustees. We could have perhaps somebody in the family who's very good with financial affairs that could take possession of the asset. So, for example, it may be a brother, sister, uncle, aunt, parents, some business person that you have very good trust in, and they can take over control of that asset for the benefit of beneficiaries. Now, we look at the other side of it, guardianship of children. That's something we also do when we do a comprehensive estate planning. And here we have designated family members or perhaps business associates to manage financial assets. But we also want to make designation of guardianship of young children, because young children, maybe they need someone in the family who's a little bit more on the nurturing side, or more the side of perhaps someone, a female in the family that doesn't have good business sense, but has a good method of perhaps raising children and caring for children. So they can be designated the guardian of the children. So now we've taken care of both approaches. We have guardians designated for children, and we have trustees designated for management of financial assets. So upon your demise, all this takes effect. And you can imagine, by not having proper planning, the consequences that we've seen in our office can sometimes be devastating. The wrong person in the family, of course, shows up and takes control of financial assets. Grandmother dies, and the nephew or niece or cousin shows up and says, I'll take over the asset, I'll manage it, and they want to put it all into some new investment plan, everything into internet stocks, for example. Well, what happens? Internet stocks go up, they go down, they lose everything. That's the type of thing we want to avoid. So we set up a committee, perhaps co-trustees. So all the financial assets are managed not just by one person, but, for example, by two. Two people in the family have to make joint decision-making authority. But keep in mind, as a married couple, you're not going to have an immediate successor trustee take effect immediately, because typically a husband and wife, unless they have simultaneous death, one will succeed the other. So if the husband dies first, the wife can take control. If the wife dies first, the husband can take control. So during the lifetime of husband and wife, we have successor trustees each other. Then second level of trustees will be perhaps the children, if we feel they're responsible. If they're too young, family members. So we've gone first from the situation of successor trustee, husband or wife, to the situation of successor trustee, family members. Okay. Now, other things we should consider, though, this living trust takes really effect upon death. Now, what happens during your lifetime? Say that you have some type of incapacity. Say you have a situation where you're not deceased, but you're in an accident, or something tragic happens, you have a stroke, or something happens to your mental ability to function. Well, that's almost more devastating for the family, because upon death, the assets can be marshaled and distributed. But when you're still alive, but you can't function in a mental capacity to the point of managing your assets, it's almost more tragic, because your family members will have to take control, but they don't have the official authority yet from the trust. So we have an interim document called a durable power of attorney. And a power of attorney is exactly that. It gives the power to you to act as attorney for that matter. And the matter we give him is financial management. So it's a durable power of attorney for management of financial assets. So your assets, for example, managing rental property, paying bills, taking care of bank accounts, anything that you do in life that requires a financial decision can be designated in that durable power of attorney. So what we do is we take that durable power of attorney and we give a specific list of powers to the agent and to the person we give authority to. And we manage real estate, manage business, all those things are designated. So if you're somehow injured, and if you're in a situation where you don't have the ability to manage your financial assets, the spouse would take over. And if this is a situation where the husband, he has complete control of a business, well, this is a time for the wife to take control of that business through that durable power of attorney. So the husband has a heart attack, has a stroke, ends up in the hospital, the wife takes control. Or vice versa, the wife has a business, the husband takes control. Or at least can manage property. Maybe the house needs to be sold, property needs to be rented out. Life goes on. Things need to be managed properly. So that durable power of attorney takes care of that interim period from incapacity until death. So now we've covered during lifetime, you have complete control of your trust. During incapacity, we have a durable power of attorney for financial asset management. And then upon death, the living trust takes effect. So we actually have everything covered from the immediacy all the way through till death. And even past that, we have managed assets ongoing. And people think that trusts are so complex, we can make them very simple. We can make a very simple distribution. Or we can do something very complex and dealing with charities and